Thank you. All right, so I'd like to go ahead and call this work session to order on AO 2020-84, requiring large hotel employees to offer rehire to employees laid off in the COVID-19 pandemic to retain eligible workers for a period of time after a change in ownership or control, and consider offering continued employment. Let's go ahead and start with a roll call of assembly members.
Miss Allard, Mr. Constant, Mr. Dunbar,
Here.
Ms. Kennedy,
Here.
Ms. LaFrance, Mr. Perez-Verdia, Mr. Peterson,
Present.
Ms. Quinn Davidson,
Here.
Mr. Rivera,
Present.
Mr. Weddleton,
Here.
Ms. Zolotel. All right, thank you.
Thank you. As usual, if members want to get in the queue, please put yourself in the chat. If you don't have access to the chat, feel free to text me. So for this work session, we are going to be doing a few things. So first, the sponsors are going to give a quick introduction. Then Dean Gates is going to walk us through the ordinance. Then Marvin Jones is going to walk us through a little bit about the local impacts and the rationale. And then hopefully we'll be able to hear from some industry members who were invited to join us today. So we'll go ahead and get started. I'll start off with some introductory remarks and then see if Mr. Dunbar wants to add. So since March, we've learned about impacts to various industries, focusing on both the needs of the employer to keep their business open, as well as the employee. When the union representing hotel workers brought forward a concern to me about protections for employees, the need to act was a no-brainer to me. This ordinance unapologetically seeks to protect the employees of the hotel industry by retention provisions for hotels with 100 rooms or more. In my opinion, we need to do everything that we can to help stabilize the life of employees who, through no fault of their own and due to COVID-19, will find themselves in the middle of large corporate-like negotiations that they really have no control over. So I look forward to the discussion today and welcome the thoughts of my colleagues as we review the ordinance. Mr. Dunbar, did you want to add anything else?
Yeah, I just want to say, with regard to the specific provisions of this ordinance, well, two things, and you'll hear more from Marvin and others, but one, this is something that's happened, this ordinance is modeled off of ordinances that have already passed in some other cities. And two, the worker retention portion regarding the transfer of hotels is motivated because there is, apparently it's already begun, but it's also anticipated a fairly large-scale consolidation in this industry, driven in part by COVID-19. And so I think, to reiterate what Mr. Rivera said, this is a particularly vulnerable group of employees who experienced a very high amount of unemployment, not due to any fault of their own. And the industry as a whole is likely to undergo a process of consolidation, again, not due to really their fault or the fault of the employees, but because of the COVID-19 pandemic. And so I think these protections are necessary given the unusual circumstances we in the industry find ourselves in. Thank you.
Thank you. So with that, we'll turn it over to Dean Gates to walk through the ordinance.
Thank you, Mr. Chair. And I thought that I would share my screen and walk through the ordinance, but I also thought that I would first take a peek at the AM here. And if you can see it now, And the reason I want to look at it first is because it illustrates the two distinct rights that are provided by this ordinance to protect hotel workers. One's the right of recall, and that one's related to those laid off due to COVID-19, the pandemic, and other crises. So it gives them priority in rehiring if they were laid off because of due to different effects. We will see that language in the ordinance. And the other distinct right provided is the worker retention on an ownership change. And so I wanted to sort of look at that first, so that as we walk through, we understand we're looking at really two different distinct rights, and they sound similar and maybe they sound like they overlap, but they are very distinct from each other. So with that, I'm going to turn to the ordinance. And we've actually talked about instead of having, excuse me.
And actually, Mr. Gates, if I can just interrupt you really quick. So I'd just like to note for the record that we've been joined by Ms. LaFrance, Mr. Constant, and Ms. Allard. Please continue.
Sure, great. So now pulling up the ordinance, you'll notice that I've started a draft S version. So, and we already have a few changes that the sponsors have agreed to insert. I will talk about that as we get to it. But I want to note on the website for this work session, we're posted the current versions of AO 2020-84 that were already published on our agenda, introduced July 28th. So I did note on the work session webpage, it says draft of these, but no, those are finals. But we will likely have this S version with some changes that I'll mention as we go through. So here, this inserts a new chapter in our municipal code, 1090, and Title 10's business and licensure related provisions. So this new chapter is about displaced workers protection. So I made this a little broader because right now this is hotel workers, but perhaps there's other industry areas that might be added to this new chapter in the future. So give it some flexibility. So the definitions here of several terms, and the couple I want to point to are the change in control. That means that's change in ownership or operation, management operation of the hotel. And that relates to a distinct right for eligible hotel workers, which we'll see in another section. I also wanted to point out the definition of hotel. So this all these rights and this whole ordinance is only limited to the larger hotels, 100 or more guest rooms. So it doesn't apply to those smaller operations and some of those like locally family operated inns, for instance. So, and we have some definitions that are really sort of common sense things to insert there. And we have a worker retention period, which again relates to a change in control. So as you go through this ordinance, you would see definitions related to change in control. Those don't relate to the retention thing, right of retention. They relate to the right for to be rehired after a change in control. So the definition of laid off employee, and here you see some markup. We had a discussion with Mr. Paul Moore. He's an attorney in California, familiar with these ordinances in other cities. And so after our discussion with him, the sponsors agreed to these changes. So I would note what they are. The first one down here, laid off employees, the hotel worker, and as you saw in AM, this relates to those affected by the COVID-19 pandemic. And a laid off employee who has been had a separation that was due to one of these reasons: government shutdown order, lack of business, reduction in force, or other economic non-disciplinary reason. So one reason it's defined this way is the pandemic is such a long duration, and it's sort of uncertain when this right might arise, and when the economic effects strike will tell that they're laying off workers. So it could be next year, or who knows how long it is. So this is defined in a manner that sort of gives it some flexibility in terms of when will it happen and how remote from the COVID-19 emergency but the economic effects are really due to it. So we have that right for a period of time. One issue here that we identified with Mr. Moore was this language number 2, and that was actually something that I, in my review, thought that belonged here, but it actually doesn't work. So we're just taking that out because this relates to the change in control, which was a different distinct right, as I've tried to mention, related to the hotel worker retention after hotel ownership change. And that right is actually different because it's not really directly related to COVID-19. It can protect workers when there's a change in control regardless. So we're taking the definition that has been in other jurisdictions, and that was in the draft that Mr. Rivera mentioned was provided to us. And one thing in that draft was it had the January 31st date. And we have learned recently that that date was intended to sort of designate the onset of the pandemic. And as you'll see, that date's sort of a trigger of related to your employment and how long before this date. But since it's related to the onset of the pandemic and the declaration of emergency for the pandemic, we've changed this. We've agreed to change this to March 11th, which is the date that the governor and the next day the mayor had declared an emergency due to the COVID-19 pandemic. So it will tie in directly with our local declaration of emergency. So I guess I don't want to spend too much time going through definitions. So here we have, I would just sort of highlight the sections. 1090-20 is notice of change in control. The hotels that this applies to need to give notice of that change prior to, within 5 days, or actually right after, and so that other employees are aware, plus an accessible language. Then there's hotel worker retention. And this relates to the change in control only. So the hotel has some obligations to their employees to the successor hotel. So there's the incumbent hotel, the successor hotel. The incumbent provides the list of all their eligible hotel workers, and those are the ones who will have that right of hotel worker retention, and they will get to work for, I think it is about 60 days after a change of control before the successor hotel owner can decide whether to actually retain them or not. So they get to time to work with the new owner or operator who can evaluate their performance and retain them afterwards. So rather than saying we're just going to replace the whole workforce with our own, so we weren't allowed to do that under this ordinance. So this next section is the right to recall, and this is the distinct right from the hotel worker retention. It relates to the laid off employees only, as that definition we saw recently clarified was related to the pandemic. And so laid off employees qualified to be first offered to rehire in the same or similar position, you know, if the hotel is rehiring, or even if not the same position, for a position they're qualified for. So it gives those laid off workers just a right of priority, not a right to have position, but a right of priority. Running down here. There are certain time periods that are relate to the effect. One is giving the laid off employee 10 days to accept or decline that first offer. So it's not, an employee doesn't have to return after they're laid off. Maybe they found some better opportunities. So they at least need to have the offer, and after 10 days, then the employer can fill the position with someone else. Then part C is a 30-day thing. If the hotel is offered someone else the position instead of the laid-off employee, or they make some determination and decline to rehire the laid-off employee, there's 30 days to give them in writing all of the reasons for not for declining to recall that laid off employee. So this at least gives that employee a list and the grounds, and so that would be helpful if they have some grievance about it. And so it gives them a little better position and fair position in terms of fighting to get me hired on the job that I had enjoyed before. And so here we see in section D some additional changes for our draft S version. This right of retention is only has this subsection D that clarifies a bunch of circumstances that it applies to. And these circumstances are also only intended to apply to the right of retentions for laid off employees to the pandemic. So this only applies to the section, not the whole chapter. And then we've changed the dates to align with the declaration of emergency. Let's see, then there's a requirement of notice. The hotel that this applies to must put notice to all their employees in a place where it's visible and they can each read it. It prohibits some retaliatory action against someone who's exercised rights provided here. And then 1090-70, it says that collective bargaining is recognized, and that if a union and employer want to alter the rights provided by the ordinance, that they can. So we're not preventing the parties from having some mutually agreeable terms that differ from what's provided here. And then 1090-80 are the civil remedies that can someone enforce here. So the municipality can enforce this ordinance if municipal attorney or I'm not sure which department it might fall under. The municipal manager maybe wouldn't have to deal with that, but the municipality can enforce this, or an aggrieved person whose rights under the ordinance have been affected. So they can take a civil action filed in court to enforce it and ask for injunctive relief, enforcing the terms rather than money damages. And then that's the end of the ordinance. And I mean, the new chapter that is to be codified here. And then we have here, I guess, let me go up a little bit. We noted that this eligible employee in right of retention, it doesn't seem to have an end date to it. So maybe 10 years from now, someone says, well, I was laid off and you're hiring and I want this position back that I used to have back in 2020. And so that doesn't make sense. But here's the trigger we have is a requiring report to the assembly about the effectiveness of that section for the right of retention in 2022. So bringing that back before the assembly so that we can consider whether we need to still need that section, or has it been effective? Do we need changes, or it's been ineffective and it should be removed? No, that remains to be seen, but at least bring back a report in 2022, 2 years from the onset of the pandemic. And so that's my rundown of the ordinance. So I'll hand it back to you, Mr. Terrell.
Great. Thank you so much, Mr. Gates. Next, I'm going to turn it over to Marvin Jones with Unite Here. And I think, Mr. Jones, I think you're on one of those phone numbers. So if you are muted right now, it's *6 to unmute yourself.
Okay, can you hear me now?
Yes, we can.
Okay, thank you. Okay, my name is Marvin Jones, and I'm the president of Unite Here, Local 878. We represent hotel and hospitality workers across Alaska. Thank you very much for having me today. Hotel workers are suffering right now like I've never seen before in the decades I've been in the industry. Many Anchorage hotels have had huge layoff, portions of their staffs are completely shut down. In Anchorage, 1 of 9 jobs in tourism related. This May, 9% of the unemployment claims in Anchorage were accommodation workers, and that's not including anybody in food service. One of our major local industries has been totally gutted. We can't force businesses to come back, but we can make sure the job still exists when it does. This ordinance would help stabilize the workforce and prevent a temporary employment crisis from becoming a permanent one. They would also ensure that when economic recovery does return, there is an orderly and efficient path for workers to return to their former jobs. It has two major pieces. The first major piece gives protection to workers when a hotel changes hands. As coronavirus stretches on, hotel owners get further behind on their debt. To give a small example, there are 12 hotels in Anchorage that have publicly traded debt called CMBS, which means we can see their payment status. On August 4th, one of those was already in foreclosure. 3 were in default, 3 were in imminent default, and only 3 hotels were current on their payments. And those are the numbers on just one small slice of local hotels. There's going to be a tsunami of hotel changing hands. So we need to prevent a tsunami of workers permanently losing their jobs. The ordinance will require new owners to keep their prior hotel employees for 90 days once the hotel reopens. Enough time for people to show their skills, prove their values, and make backup plans. The second major piece is job recall rights for laid off workers. It establishes a process for workers to be brought back for a layoff by seniority. That will give workers economic security and confidence, and they can better plan their economic futures knowing that they will have priority for their old jobs. This will ensure families fairness in rehiring when hotel jobs return, and it will ensure that experienced local hotel workers remain tied to their former jobs and don't have to leave the state or the area, so that they can be part of the recovery when it happens. Last, it provides for a smoother labor market recovery when business returns by ensuring that workers can return to their former jobs. Both of the pieces of the ordinance would only apply to large hotels with 100 rooms or more, which covers 81% of rooms within the municipality and targets hotels' best positions to comply with the ordinance. This is enough to make a huge impact for workers, but without any impact on small business owners. Thank you for your time for listening to my comments.
Thank you, Mr. Jones. So next, would like to open it up if any of the members of the hotel industry are with us today. I know we reached out and invited several to join us, but if any would like to comment or have any questions, thoughts, would enjoy hearing that at this time. Again, if you're on one of those phone numbers, it is *6 to unmute yourself.
And can I just say, Felix, before perhaps someone jumps in, that my aide Lillian reached out to 30 different hotels and had a number of conversations. And from her conversations, it appeared that I don't think those hotels were planning on speaking today, but they were listening in. But certainly we still welcome them if they want to speak now.
Thank you, Mr. Dunbar. I'll go ahead, just give a little space if anyone would like to speak. Otherwise, we welcome any written testimony or thoughts after the work session before we take action on this. Okay, not hearing anything. Then if folks have any questions then based on everything that they've heard, please put yourself in the queue. I'm going to go ahead and start with Mr. Weddleton.
All right, thanks. Yeah, sorry, I just read this briefly as Dean was talking, and I didn't catch all perhaps the changes in the S version. So I had a couple questions. It seems to me, if some someone closes down a business, whatever type it is, and for some period of time and then reopens, the natural thing would be to get people who know the business, know how it operates, and would already be doing this. I mean, this seems a little odd that it wouldn't already be natural for businesses, and businesses would already want to rehire in an orderly way. So it just seems odd. This is already what I think naturally happens. There's, and I guess you have a required that the two things kind of jump out, and one is that operator, I guess they have to go. And I can see, so they have to guarantee that they would rehire their old employees. So, and what I heard from Mr. Jones is that lets those employees feel comfortable that when that reopens, whatever date that might be, that they would be rehired, and gives them some confidence, which is a good thing. But there's no counterbalancing thing for the businesses that, I mean, these workers could also go find another job. And then when the hotel goes to get them, and they go, oh, well, I've lost a third of these employees because they've gotten other jobs. And so this unfairness there. But then another one, what if a union operator buys a non-union hotel and he has to rehire people who aren't in the union? Is that proper? Or what about the flip side? Someone buys a union hotel and they're not a union operator. Then how does that work? Then all of a sudden these employees, they quit the union and work for this company, or what would work there? So a couple, sorry, it's a little disjointed, but a couple questions in there for whoever, and perhaps Mr. Jones could answer, or the sponsors.
Yeah, Mr. Jones, I'd like your input on any of those 3 points that Mr. Weddleton made, and then we can see if others have input on that as well.
Okay. Yeah, I'd like to have a legal attorney, Paul, answer that one, if you could. What part of that?
Sure, I'm happy to. Can you hear me?
Yes, we can hear
Great.
you.
So my name is Paul Moore. I'm an attorney and have worked on similar ordinances in other cities, and there's a similar law pending in the California State Assembly and Senate. So there were 2 questions that I heard. The first one was about the sense of fairness for employers. There's no obligation for an employee to take a job. There's simply an obligation for an employer to offer the position to a former employee. And that seems as it should be, because it wouldn't be permissible to mandate that an employee work for a particular employer. That would be unconstitutional. You can't require people to work or to work for a particular employer. The second, but the important point, I think, is that the way this works is that there's simply a requirement that the employer make an offer to a former employee, and then that employee has a limited period of time to accept or decline that offer. I think, given the state of the economy, it's likely that most, if not all, of those who have been laid off will jump at a chance to continue working at their former place of employment. The second question had to do with what happens if there's a unionized hotel employer that purchases a hotel, or a non-union hotel employer that purchases a union place. So the way that federal labor law works is that particular places of employment are unionized or not unionized. An employer, as an employer, say Hyatt, for example, is not unionized as an employer. There are only particular work sites that are either unionized or non-unionized. So if an employer that had unionized work sites purchased or took over management of a hotel that had a non-union workforce, that workforce would continue to be non-union until they decided for themselves that they wanted to have a union. Where an employer takes over a unionized property, there are a number of federal labor laws that apply to what happens after that. And those would continue to apply. That is, the obligations of the new employer would be set by federal labor law. They wouldn't be determined by this ordinance. So federal labor rules would apply as to whether that new employer would have to recognize the union when it took over. But that wouldn't be a subject of, and couldn't be a subject of this ordinance. I hope that's clarified, and I appreciate your giving me the opportunity to address you on those points.
Yeah, that's very helpful.
Mr.
Thank you.
Edson? Okay, thanks. Any other questions? Ms. Kennedy.
Thank you, Mr. Chair. I guess that leads me to the question of then which hotels, can we name the hotels right now that this would be, that this would apply to? Because it sounds like, I guess from just the last comment from the last speaker, it sounds like this would not actually apply to the unionized hotels that currently have sites that currently are in our municipality, that are above the size, the above 100 or more size. So do we know how many hotels that this would actually even apply to?
And this is Paul Moore. I apologize for breaking. I just wanted to clarify for Assemblywoman Kennedy that if I suggested that, then I miscommunicated my point. This ordinance would apply equally to union and non-union properties above a certain size, the size threshold. So the ordinance would apply equally. I was speaking about what impact it would have on unionized and non-unionized properties for purposes of whether they would be or remain unionized. And I meant to say that the ordinance doesn't address that, doesn't have any relationship to that. That's purely an issue of federal labor law. So I apologize if I was not clear. Thank you.
Thanks. And I
Okay,
asked Mr. Gates to go to the language regarding the supersession by collective bargaining agreement, which you see before you, the 10.90.070. Ms. Kennedy, did you have any follow-up?
Yeah, a little bit, just further clarification then on what role federal labor law would play in this. And so I guess maybe that speaks to the supersession clause. So can somebody explain to me how this would basically trump federal law, or would it be the other way around? Federal labor law would actually be the authority in any of these questions, regardless of this particular ordinance.
Which one of the attorneys would like to answer that question?
I'm happy to give my view of it. This is Paul Moore. So federal labor law is the supreme law under the Constitutional Supremacy Clause. So if there is a question of having to do with labor management relations, which is the subject of federal labor law, that is whether workers are or remain unionized and how they decide whether or not they want a union, that is an issue of federal labor law. And that is not something that is affected by or a subject of this ordinance, nor could it be. Many laws at the federal, state, and local level have provisions that say that where there is a collective bargaining agreement, that the unionized employer and the union can bargain for some different rules, or a different rule that applies. This goes all the way back to the 1930s and the federal overtime and minimum wage laws. And so the provision that's on the screen here simply says it doesn't have anything to do with whether workers are unionized or not unionized or how they decide. It simply says that, for example, if in a unionized workplace there are complicated seniority laws that apply to how recall will go forward, this isn't intended to duplicate or supersede those bargained seniority rules, for example. And so a unionized employer and a unionized workforce can bargain for a different arrangement. Again, that's a separate question from the question of whether workers will be unionized or remain unionized or be non-union. It simply has to do with the ability of a unionized hotel and a union to bargain for a different set of rules than are prescribed by the ordinance. And again, it's a common feature in many state, federal, and local employment laws. Thank you.
Thank you. And then to answer an earlier question, Ms. Kennedy, that I forgot to
add something.
Actually, Dean, if you don't mind, I'll let you go right after I'm done. So to answer a quick question that you asked earlier, Ms. Kennedy, about is there a list? Yes, there is a list of hotels that are 100 rooms or more. Mr. Gates?
Thank you, Mr. Chair. Oh, yes, and you wouldn't want to codify that list, I think for obvious reasons. Those would change. But related to the question about unions and the National Labor Relations Act, and I agree with Mr. Moore that as a federal law, under the Supremacy Clause, it would supersede anything, and that this provision sort of recognizes that 1090-70. And my additional comment I wanted to add is provisions like this are common. I do see them in other I've seen them in other jurisdictions, but I also believe we have a similar provision in our own Title III, Chapter 330 or 370, which is our employment and personnel rules. Chapter 330 I think says that, or Chapter 370 is about our collective bargaining with unions for the municipality, and I believe it has a provision that says our personnel rules. Chapter 330 that apply to municipal employees will apply to the union employees unless altered by a collective bargaining agreement. It's very similar to this. Our own code recognizes the National Labor Relations Act rights that collective bargaining will supersede our local personnel rules. And I would just qualify the caveat that I'm not an employment law expert, so I often defer to our employment law experts in the municipal attorney's office.
Thanks. All right, any further questions? Ms. Kennedy?
Thank you, Mr. Rivera. And I guess I would take issue with the idea that this is a no-brainer because I think there's a lot to think about here. And of course, some more questions. One of the things that I'm curious about is how well, first of all, we're obviously creating a whole new set of rights for a certain group of people. And we're also setting about potential remedies and punishments and the ability to sue in court. And anyway, so we're actually creating quite a bit of requirements, restrictions, like I said, damages, penalties. So in thinking about this particular group and, and the hotel workers, there's a lot of different industries that are going to be doing some pretty significant adjustments, and there's going to be a lot of buying and selling. And I'm thinking of right now, like the airline industry. There are several airlines throughout the world that have already gone bankrupt. There are several that are consolidating. And so I'm just kind of thinking, okay, why would we do this particular group? And are tomorrow, next week, are we going to decide that, okay, now we're going to do something for the airline attendants. We're going to do something for pilots. We're going to do something for the bus drivers, for the tourism industry. I mean, I think a lot of things are going to be very difficult to judge right now in terms of who survives this COVID thing, and what's going to be their way of actually figuring out how to recover. And I think I'm along the lines of what Mr. Weddleton said, is it seems like the no-brainer part is that when these companies do start to build back up again, they're going to want the employees that are well qualified and experienced, and they are going to be the first ones asked back. But I guess I'm curious as to what extent we go to requiring these kinds of actions of the various industries that are going to be doing this same kind of shifting and buying and selling and trying to rebuild. So what's next? Thanks.
Thanks. I'm assuming that's a question for the sponsor. So, Mr. Dunbar, if you want to answer that one, and then I will have some thoughts as well.
Sure. Well, I mean, I think some of those ideas Crystal just brought forward might be good ideas. Who knows? I think there are a variety of federal, state, and local protections for different industries that are being contemplated right now. But I would say, on Wednesday night, we passed $7 million specifically for the restaurant and hospitality industry to follow up $7 million more we had passed on Friday specifically for that industry, because we recognized that industry was uniquely harmed by COVID and by the health measures that were taken. In a similar way, there probably isn't any other single group of folks who have been put out of work in higher numbers than hotel workers this summer. In conversations with Marvin and with other folks, it's just been devastating for them. And their road back is going to be a long one, particularly in Alaska, where the hotels won't really ramp up again until next summer, likely. So I think there is reason to focus on this group of workers first, although I agree that there actually are probably stronger labor protections needed for a wide group of workers all over the country. And I said at the beginning of this pandemic that we've given a lot of thought to employers. We've given quite a bit of thought to the public, but employees are a group that have been falling through the cracks in our response since March. And so this is one, I think, relatively modest step for one group of employees who have been uniquely harmed. Thanks.
Thanks. And I don't really have much to add from what Mr. Dunbar stated, other than, you bring up a good point, Ms. Kennedy. I think what we have before us is an opportunity to do good for one particular group of employees that, as Mr. Dunbar stated, has been uniquely harmed by this pandemic, and not only in the municipality of Anchorage, but throughout the state of Alaska, as well as throughout the United States. And so if we have the ability to do good by those employees in the municipality, then I think we should take that opportunity. And if there are other opportunities to do good for employees in other industries and to assist them through this global pandemic, then I think we should take those opportunities. I haven't heard of them as yet, but if there are more things that we should do, then I will absolutely take that opportunity to do right by the employees and workers of the municipality. So I appreciate the question. Mr. Weddleton?
Oh, thanks. Yeah, I may have missed it, but I pursue it again. And again, probably Mr. Jones or some of it. I mean, this Are we seeing that hotels are changing ownership or closing then reopening and hiring whole new batches of people? Which is kind of implied by this. I mean, are they not already doing what this recommends that they do?
This is Mr. Jones. We as I stated earlier, we expect this. What we see across the country in our research, we also see that some have already been turned over to debt collectors. And so, our number one goal was to protect the workers here in our municipality. And if it was a situation where an employer a new employer took over, I've been in the industry for 31 years, and it's not always that because you're a good worker, you are retained. That's just not the case. And so our goal is that we look at it and say, well, we've been hit more than anybody, or been affected more than anyone during this pandemic. And hopefully the goal was to protect the workers in our community. There's 35 of the 70, I think it's around 75 hotels that are over 100 that would be affected. And one of the things too is that if a new owner came in, there's more to just their job. Some of these workers have pensions. Some of these workers have health benefits and strong ties to the employer, and they may lose all of those if an employer just decide to have a whole new staff. So they have a lot to lose more than just their job. They have their livelihood, which could have been extended for 10 plus years. So there's a little bit more than just losing your job. And so hopefully that the decision would come down to protect the livelihood of all the workers in the hospitality industry.
Could I follow up, Chair? Do we have time?
Go ahead.
Yeah, okay, well, I appreciate that because that shines a whole new light on it. So I guess kind of the view would be, a hotel fails or whatever reason it's sold, and the new owner, it sounds like could shed some costs by, if they hire the old employees, then they would owe them their pensions and so on. But if they don't hire those old employees, then they don't inherit those costs. And so that would create an incentive for the new buyer to not hire the previous employers. Is that the case, Mr. Jones, or perhaps Mr. Moore?
Marvin, I don't know if you want to start off on that.
Yeah. My more of my position was to protect what the employee had invested in the company. So if they had health insurance for them and their family, that just wasn't immediately cut off, that they was able to sustain that for them and their family for whatever time that was permitted here during this new ordinance. The second thing, like I said, whether it's health insurance, whether it's a pension, and just typical job security, a new employer obviously has every right to pay his workers what they want, but on the other hand, too, they could come in and they could reduce the amount of money that you had been making for you and your family for X amount of years. So our whole goal, or hopefully the whole goal, is to protect the workers in our municipality or in our community, and that's just hopefully that is the goal.
One more, Chair.
Go ahead.
Okay, thanks. Okay, so I guess this is actually real helpful. So I don't quite see how this would protect their insurance, but is there something here that I missed that would say they would rehire them at their previous pay? Because that gets to core issues there.
No, I don't think so. Like I said, that was not the focus of what I was trying to make a point of. It was just basically whatever those workers had established at that point could all be gone. It could or it could not. I don't know. I think the whole goal was to protect the livelihood of the workers who were there, just because of the numerous turnovers that are possibly there to happen and that are in the process of happening.
and then I'd like to turn it over to the attorney, see if you have a answer to that question.
Yes, thank you. So the worker retention aspect of this ordinance is a concept that has been adopted for the hotel industry and for other industries that frequently experience changes in employer without a fundamental change in the nature of the business. So there are many cities across the country and some states that have adopted versions similar to this one. And like all employment laws, I would say, most employers who are out there do the right thing. Many of them do. And, what happens when there's a change of ownership is no different. Employment laws are there because there are a minority of employers who, when there is a change in ownership, look to shed themselves of the cost, sometimes the appearance of longstanding employees of their predecessor. And this is a law that has been adopted again by many cities for those probably minority of cases in which a new employer coming in looks to wholesale change and destabilize the workforce of its predecessor. This isn't a permanent employment measure. This doesn't say you have to keep people forever. It's simply a kind of pause, a transition employment period that says when you take over an existing hotel operation, you keep on the existing employees, again, subject to staffing needs. It's not a make work provision, but the extent you have need for employees, you keep them on for a transition period so that they can demonstrate to you their worth. Rather than wholesale laying people off or terminating them and bringing in a new workforce. So that's the intent of the measure, and I think the Assemblyman is correct that there are many employers who are out there where that would be their natural inclination. And just like any employment law, this is directed at those situations in which a new employer would have a different approach that it would take.
All right, thank you. That's very helpful.
Thanks. I see, Mr. Gates, you're highlighting things. Did you want to add anything else?
No, I was simply trying to pull up the language that was relevant to the discussion.
Thank you. Thank you, Mr. Weddleton. Any other questions? Again, while folks are thinking, I want to invite members of the industry, if you have any written comments that you'd like to send to the Assembly after reviewing the ordinance and considering the discussion today, I want to invite you to provide those to us. We have this before us on the August 25th meeting for a public hearing and a vote. So the sooner that you have any thoughts, the better we can take those under consideration and potentially suggest any changes to the ordinance as appropriate. So again, open it up one last time. Any other questions from members? If not, I'm going to go ahead and end the work session. 11:10.